This lecture will be based on the MCQ questions I had given to law students of the Law and Public Corporation subject. The first MCQ is about creation of an LGU, and to answer this, you have to return to Section 14 of the Local Government Code. It says, when a new local government unit is created, its corporate existence shall commence upon the election and qualification of its chief executive and a majority of the members of its sanggunian, unless some other time is fixed therefore by the law or ordinance creating it. So important keywords, election and qualification. Now, jurisprudence tells us that election includes proclamation, while qualification includes assumption of office. And so the correct answer of this MCQ question could only be it commences upon the election, proclamation, assumption of office of its chief executive and majority of members of the Sanggunian. This second question is about the dual personality of an LGU. Now let's review. An LGU has dual personality, political and corporate. The political also means public and governmental, and corporate also means private and proprietary. And so immediately you realize that the answer to the question is all of the above. It is both political and corporate. Letter A, correct. It has a political personality that is public and governmental, correct. It has a corporate personality that is both private and proprietary, all of the above. This MCQ question under the General Welfare Clause, Section 16, LGUs can exercise just about any act for the good of the constituencies by the power that is tacitly granted. Now it rings a bell because immediately you realize that that is wrong because of the word tacitly granted, because it should be explicitly granted. Now, this item is a big problem because of the word particular. Because when you exercise the power under the General Welfare Clause, you should also observe the Equal Protection Clause. It cannot be only redounding to the good of particular constituents. So the answer, correct answer, could only be that under the General Welfare Clause, LGU can exercise just about any act for the good of the constituencies by the power that is necessary, appropriate, or incidental for its efficient and effective governance. Next question. An LGU is considered to have properly exercised its police power only when the following requisites are met. Now be attentive here because A, B, and C are in fact the requisites that must be met for the exercise of police power by an LGU to be considered properly executed. First, the interests of the public generally, as distinguished from those of a particular class, require the interference of the state. So when the state needs to interfere because the interest of the public generally and not only the particular class, when the interference of the state is needed, then that calls for the exercise of police power. And in fact, this is the Equal Protection Clause that must be observed in exercising police power. Second, the means employed are reasonably necessary for the attainment of the object sought to be accomplished and not unduly oppressive. And in fact, this is the due process clause. Reasonability, and it should not be unduly oppressive. These two are embodied in letter C, the Equal Protection Clause, as well as the Due Process Clause. So the answer is all of the above must be observed for the exercise of police power by an LGU to be considered legitimate. The next question is about nuisance. The power of LGU to abate nuisance emanate from the General Welfare Clause. Now the choices are: may go through judicial proceedings, second, must always be done summarily, and third, may be done extrajudicially in cases where the nuisance is nuisance per se. And if you're attentive, immediately you realize that there's a problem with letter B, because it is wrong to say that it must always be done summarily. In fact, it should be done judicially, with the only exception that nuisance per se may be abated summarily. So we have the problem with the term always be done summarily, because it can only be done summarily for exceptional cases like instances of nuisance per se. So that is wrong, and immediately you realize that the answer cannot be all of the above, because we have one item which is wrong, must always be done summarily. And so we are left with A or B. B is apparent, is obvious, it is correct. May be done extrajudicially, means summarily, in cases where the nuisance is nuisance per se. And so C is the answer, and A is debatable. Actually, this is wrong because of the permissive word may go through judicial proceedings. It must go through judicial proceedings, and not just may, but must go through judicial proceedings, except in instances where the nuisance is considered nuisance per se. The sanggunian of a municipality cannot subpoena witnesses nor punish non-members for contempt because of all the reasons enumerated below except one. So be careful with the word except one. Also in bar exam, sometimes this formulation of question, type of formulation is given. So you are looking for the wrong reason, because all the others are supposed to be correct reason. You are looking for the wrong reason. And what could the wrong reason be? Let's go to jurisprudence. According to Negros Oriental to Electric Cooperative Incorporated versus Sangguniang Pangsa de Dumaguete, there is no provision in the local government code explicitly granting local legislative bodies the power to issue compulsory processes and the power to punish contempt. So the wrong reason is the sanggunian, being legislative in nature, cannot exercise any quasi-judicial function. That is obvious, my dear friends, because in the local government code, there is, in fact, a section there, or even a chapter, talking about the quasi-judicial powers of the sanggunian. This question, the requisites of a valid exercise of the power of eminent domain are the following, except one. Now, there's the word again, except one. So you are looking for the wrong reason, and immediately you realize that letter A is wrong because of the word resolution. It cannot be a resolution. It must be an ordinance. So before a local government unit can expropriate, there must be an ordinance. If it is just a resolution, it is not valid, because a resolution is just the expression of the sentiments of the members of the sanggunian, and it needs law, no, the color of law. So it has to be covered by an ordinance. The following are the requisites of an LGU to expropriate agricultural lands, except one. So you're looking again for the wrong answer. So For an LGU to expropriate agricultural lands, let's go through them. It must be for public use. Correct. Public use is very important for an LGU to expropriate private property. It must pay just compensation. As distinguished from police power, eminent domain, the power of eminent domain involves payment of just compensation. Now let's look at this. The LGU must require prior authority from DAR since it is an agricultural land. So the question is, if an LGU would like to expropriate an agricultural land, does it need prior authority from the Department of Agrarian Reform? Now let's go to jurisprudence. In the case of province of Camarines Sur versus Court of Appeals, if LGUs could no longer expropriate agricultural lands needed for construction of roads, bridges, schools, hospitals, etc., without first applying for conversion of the use of lands with the DAR, because all these projects would naturally involve a change in the land use, then, in effect, it would be the DAR which would scrutinize whether the expropriation is for public purpose or public use. So the answer is, the wrong answer is the LGU must require prior authority from the DAR. The following are exercises of eminent domain and requires payment of just compensation. We said earlier that under section 16, there are two powers that can be exercised there, the police power and the power of eminent domain. And when it comes to power of eminent domain, expropriation, there must be payment of just compensation of the property being expropriated. Police power, you not need to pay. So let's go through them. The forced taking of church land for the construction of public market. Yes, it can be expropriated. Church land can be expropriated. But in one of my lectures, I was saying that I would like a case to reach the Supreme Court challenging expropriation of church properties on the ground, and that is my own opinion, on the ground that church properties are already public in nature in the sense that it is dedicated to public use. But there's no Supreme Court decision on that yet. So meanwhile, for as long as there's no law and jurisprudence along this reasoning, then we should answer that the forced taking of church land can be done through expropriation, but for the construction of public market, but of course there should be compensation. The forced taking of private land for road expansion, yes, of course. And then here, number 3, that is police power. And in fact, there is a case in Makati, a subdivision in Makati. The subdivision was forced open in order to open the road, in order to decongest the traffic somewhere in Makati. And that is an exercise of police power, and it does not need any compensation because it does not partake of the power of eminent domain. Now, for an LGU to validly close a road temporarily for the undertaking of public works, telecommunications, or water work, the following must be observed. Take note of the word temporarily. We're just temporarily closing a road, not permanently closing it. So the mayor may order such closure, provided that he specifies the duration of the closure in a written order. So no need of an ordinance because it's just a temporary closure, and no need of the consent of the majority of its constituents, but the mayor may order such closure provided that he specifies how long it will be closed, and it must be in a written order. The following statements are correct except one. So we are looking again for the wrong statement. Now, the first statement, as a general rule, the state may not be sued without its consent. Remember, we are looking for the wrong answer for the wrong statement. So the first statement is correct. As a general rule, the state may not be sued without its consent. It can only be sued if it consents. Now, this second statement, the consent must be expressed clearly explicitly, unequivocally, so that the state would not be disturbed in rendering public service by unfounded lawsuits. Sounds correct, but the word must be expressed makes the statement wrong, because in fact the consent may be implied when the government enters into business contracts. So it 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 it, it may not always be expressed clearly, explicitly, and equivocally, because there are instances when it can be implied, and that happens when the local government unit enters into business and descends into the level of merchants. Municipal corporations may be sued on the following basis: respondeat superior. Now let's have some lectures here on the nature of the responsibility of local government units. Now, be very clear about this. When LGUs are exercising political or governmental powers, now it cannot be held responsible. It can only be held responsible when it is exercising corporate powers, private powers, corporate powers. Now, in the case of Municipality of La Union versus Firme, it has already been remarked that municipal corporations are suable because their charters grant them the competence to sue and be sued. Nevertheless, they are generally not liable for torts committed by them in the discharge of governmental functions, and can only be held answerable only if it can be shown that they were acting in proprietary capacity. So corporate capacity, if acting in corporate capacity, LGUs can be held liable for torts. It can be sued. Okay. In permitting such entities to be sued, the state merely gives the claimant the right to show that the defendant was not acting in governmental capacity when the injury was committed, or that the case comes under the exceptions recognized by law. Failing this, the claimant cannot recover. So, for example, if the driver of an LGU truck um, runs over a pedestrian, and the pedestrian dies before reaching the hospital, then the LGU may be sued, but the issue there to be proven is whether or not the driver at that time was performing governmental act on behalf of the LGU. If it is performing governmental duty, then the LGU cannot be held liable by the principle of respondeat superior. But if it is performing the function, the corporate function, the corporate personality, we know that the LGU has dual personality. If it is along the corporate personality of the LGU, then the LGU may answer for the tort committed by the driver doing corporate duties for the LGU. The following are true in cases where the local chief executive negotiates and secures financial grants or donations in kind in support of basic services or facilities enumerated in Section 17 of the Local Government Code of 1991. Now be alert, because all these are in fact the requisites. Number one, approval of the national agency concerned is required only when the projects financed by such grants or assistance is with national security implications. And second, the local chief executive, within 30 days upon signing of such grant, agreement, or deed of donation, report the nature, amount, and terms of such assistance to both houses of Congress and to the President. And letter C, implementing rules require NEDA, DILG, to assist LGUs in the granting institutions or donors in the execution and implementation of the agreement. So our answer is all of the above. And that is under Section 23 of Republic Act 7160, the Local Government Code of 1991. Now, let's repeat, let's inculcate, because these are the requisites for the LGU in securing grants. First, it needs the approval of the national agency concerned only when the projects financed by such grants or assistance is of national security implications. Second, there is a requirement that the local chief executive, be it mayor in the case of a city or governor in this case of a province, the local chief executive within 30 days upon signing of such grant agreement or deed of donation, report the nature, amount, and terms of such assistance to both houses of Congress and to the President. And lastly, under Section 23 of RA 7160, the implementing rules require that NEDA and DILG should assist LGUs, the granting institutions or donors, in the execution and implementation of the agreement. The sources of powers of LGUs are, all of these are correct, of course, the 1987 Constitution, the 1991 Local Government Code, and the Charter of the LGU also, and statutes and case law. Now, LGUs have constitutional, statutory, jurisprudential powers. Now, suppose there's a question. What if this question popped up? What kind of power is the power of LGU to tax? The answer is both constitutional and statutory. Why constitutional? Because the power to tax is in the Constitution, Section 5, Article 10 of the 1987 Constitution. And the power to tax is also statutory. It is in Section 18 of Republic Act 7160, the Local Government Code. Now, what are the other classifications of LGU powers? It's very important. Number one, governmental. For example, power to legislate. And proprietary. Immediately you realize that number one pertains to the dual personality of the local government unit. So governmental and proprietary. So it has governmental powers and proprietary powers such as operating public market. Codal. 1991 Local Government Code is an example, the power to close local roads. And we have non-codal powers, example, power of operational control over police, because it is not in the Local Government Code, it is in Republic Act number 6975 and 8551. Devolution, for example, of training services, it is under the TESDA authority pursuant to Republic Act number 7796. It is non-codal in the sense that it is not carried by the Local Government Code of 1991, but it is covered by special law, Republic Act 7796, in the case of TESDA. Number three, state delegated. For example, police power is state delegated. Police power is not inherent in local government unit, but it is delegated. Devolved powers, for example, the barangay daycare centers are devolved powers. Express, the power to create an office. And there are implied powers also. The power to create an office carries with it the implied power of abolishing that office. Executive power, the power to veto an ordinance, the power of the mayor to veto an ordinance. Legislative, the power to enact an ordinance, pertains also to an LGU. Next, the general legislative, the power to issue business permits. Police power also, power to impose curfew. Intramural, within the walls, that's Latin, intramural, within the walls, the power of eminent domain. And extramural, police purposes. Okay, number 8, mandatory, power to deliver basic services as part of devolution, Section 17 of the Local Government Code. Discretionary, for example, the power to expropriate a piece of property is discretionary upon the local government unit. Internal, the power to adopt the Sanggunian, internal rules and procedure, and they have also external powers, the power to enact zoning ordinance. Then there are powers specific to an LGU. For example, the power to legislate. There's also the power specific to, there are inter-LGU powers. For example, the power to enter into collaborative alliance with other LGUs. Now, let's go to the more controversial topic, moral turpitude. You know, at the recording of this lecture, the raging issue is the disqualification of Bongbong Marcos, Ferdinand Marcos Jr., from running office of president. And the problem of moral turpitude is being presented by those seeking his disqualification, because from 1982 to 1985, he failed to file his ITR. Okay, income tax return. Now, actually, prior to the BBM disqualification controversy, the problem of moral turpitude already appeared as early as in the 1920 case in Re Basa. And we find this in the concurring opinion of Justice Brion in the case of Teves versus Camelec. Now, Carlos Basa, a lawyer, was convicted of the crime of abduction with consent. The sole question presented was whether the crime of abduction with consent, as punished by Article 446 of the Penal Code of 1887, the old Penal Code, involved moral turpitude. The court, finding no exact definition in the statutes, turned to a law dictionary for guidance. And there was no definite definition, no specific definition, clear definition of moral turpitude. I think that's the reason why there's so much cacophony now about the issue, because Supreme Courts are not really very clear in defining what moral turpitude is. And since that year in Rebasa, they turned to a dictionary for guidance, and the dictionary says moral turpitude includes everything. What could be clearer than that? It includes everything which is done contrary to justice, honesty, modesty, or good morals. Now, although no decision can be found, this is according to the decision in Rebasa. Although no decision can be found, we have decided the exact question, it cannot admit of doubt that crimes of this character. What was the crime of Attorney Basa? Abduction with consent. Crimes of this character involve moral turpitude. The inherent nature of the act is such that it is against good morals and the accepted rule of right conduct. There you go. Accepted rule of right conduct. Good morals and the accepted rule of right conduct. And since we have relative, amorphous, and various conceptions of morality, and probably that is the reason, as one author would put it, that is one of the reasons why in almost all jurisdictions, moral turpitude is not given a definite, specific, clear-cut definition. Let's go to the questions. The following are crimes involving moral turpitude. Now, slight physical injury, it's not moral turpitude. Illegal recruitment, it's not moral turpitude. Overspeeding is not moral turpitude. But there you go. Income tax evasion is involving moral turpitude. The following crimes involve moral turpitude except the following. So we are looking for the crime that is not moral turpitude. Libel is, intriguing against honor is, perjury is, and the answer is carrying of deadly weapons. Now, you may be confused. How do we know if it is moral turpitude and it is not moral turpitude. Now, we go to the, in that case, Teves versus Comelec, Justice Brion has given some indicators, approaches in evaluating whether or not the crime involves moral turpitude. And the first approach is called the objective approach. Look at the act itself, independent of the person doing it. Now, if the act is inherently immoral, then it involves moral turpitude. Now, what do you mean by inherently immoral? It means it is bad in itself, mala in se, bad in itself. And you are safe in saying it is bad in itself if it is not a special law, because special laws cover actions that become bad because there is a law prohibiting it. For example, that's why we said earlier that carrying of deadly weapons is not a crime involving moral turpitude, because you carry a weapon. Nothing wrong with carrying a weapon, but it becomes wrong now because there is a law punishing it. We have the in our jurisdiction, carrying deadly weapon is punished by the law, illegal possession of firearms. If there were no law on illegal possession of firearms, then no problem with carrying deadly weapons, because for as long as you don't use it to kill anyone, use it illegally, then it's okay to carry deadly weapons. But now it is bad because there's a law prohibiting it. Therefore, carrying deadly weapon is not bad in itself, it's not mala in se, and therefore it does not involve an act that it is not an act involving moral turpitude. Also, illegal recruitment, because in one of the cases decided by the Supreme Court, recruitment is not bad in itself, but then because there is a law that specifies some requirements and requisites, and you have to follow those requisites, then we already have the so-called illegal recruitment. But without that law, recruitment is okay. Every business endeavor will recruit. You know, every corporation will recruit. Every people recruit people for certain jobs. Okay, but it becomes illegal now, it becomes bad now, not bad in itself, but it becomes bad now because there is a law that impose certain requisites and requirements. So for an act to be for an act to involve moral turpitude, it must be inherently immoral. It means it must be bad in itself, even if there is no law punishing it. So the clue there is that it should not be covered by a special law. The second approach is look at the crime, the elements of the crime. First, we look at the crime. The first approach, look at the crime, but check if it is a special law or it is not a special law. Look at the crime, but check if it is bad in itself or it became bad because of a special law punishing it. If it is bad in itself, then it involves moral turpitude. Second, still you look at the act itself, but consider now the elements of the crime. And if one of the elements is fraud or the intent to defraud, then you are sure that that crime involves moral turpitude. The third approach is take the offender. Before we were looking at the act itself, independent of the offender. Now look at the offender. If the offender is motivated by ill will, indicating depravity, then it involves moral turpitude. And this is where Justice Carpio is coming from, because according to Justice Carpio, this is Justice Carpio's opinion, the case of Bongbong Marcos, Ferdinand Marcos Jr. involves moral turpitude because the repeated non-filing of ITR from 1982 to 1985 shows ill will and it indicates depravity. And also in that article written by Justice Carpio, he also pointed out that although the Court of Appeals from conviction from Quezon City Court, then it went to the CA, the Court of Appeals, cancel the imprisonment. According to Justice Brion, although the CA canceled the imprisonment, but in the very decision of the CA asked BBM, Bongbong Marcos, to pay deficient taxes. So according to him, there is an element of tax evasion, and we know already that tax evasion is a crime involving moral turpitude. But again, this is the opinion of Justice Carpio, and until the COMELEC comes with a decision on the disqualification case, and until it reaches the Supreme Court and reaches finality, then we are not really sure of the answer, because this involves some controversial elements. But suffice to say, we have to learn the rudiments now. We are learning this in class, the rudiments and the nature of moral turpitude. Let's just wait and see how the Supreme Court will decide on the disqualification case of Ferdinand Marcos Jr. Now, let's go back to the questions so that in case this comes out again, then we are sure we would get the right answer. So the first question is, one of the three approaches in determining whether a crime involves moral turpitude. The crime involves moral turpitude if it is immoral in its face as positively determined by law. So we have a problem with the word positively determined by law, because this is already talking about mala prohibita. And we know that moral turpitude should be mala in se, not mala prohibita. So letter A is wrong. Then letter B, of course, is wrong. It is mala prohibita. No, if it is mala prohibita, it does not involve moral turpitude. It must be evil in itself. Now, not to pay taxes is evil in itself. Remember that taxes, that's the lifeblood of the country. The country economy will die if we will not support the country by paying our taxes. That is inherently immoral. And so the answer is letter C. The act itself is inherently immoral. Mala in se, evil in itself. Now, another question is, one of the three approaches in determining whether or not crime involves moral turpitude is to look at the act itself. Okay, the court recognized, letter A, that as a general rule, all crimes of which fraud is an element are looked on as involving moral turpitude. Correct. Letter B, crimes requiring fraud always involve moral turpitude. Correct. And letter C, crimes involving intent to defraud always involve moral turpitude. So the answer is all of the above. And another question here involving the third approach. He is motivated by ill will, indicating depravity. So look at the person. If the person committing the crime is motivated by ill will, indicating depravity, so A is correct. When he is a minor, no, nothing to do with the moral turpitude we are discussing. And number three, when he has committed the crime against women and children, nothing to do again with our discussion on moral turpitude. So the answer is not all of the above, but letter A, he is motivated by ill will, indicating depravity. And here again, we have the very general definition of moral turpitude, that it should be against justice, right and duty, good morals. But then again, I say that these definitions are very general, and in some jurisdictions, in other jurisdictions also, moral turpitude is treated generally. And the reason one author says is because we have different concept of what is accepted norm of morality. Thank you for joining me. I hope that you have learned something from this lecture series. Number one, I'm Attorney Father Dan Domingo Los Angeles. God bless you. So